ARIS would like to acknowledge that the lands we meet on today is the traditional lands for the Kaurna people, and we respect their spiritual relationship with their country. We also pay respect to elders from other regions and Aboriginal people who may be joining us today in this webinar. APEA comprises of the Legal Services Commission, the Office of the Public Advocate, South Australian Police, known as SAPOL, the Public Trustee, and ARIS. APEA was initiated by ARIS in the late 1998 with 5 South Australian agencies who deliver frontline services, combining their efforts with a view to improving and challenging the way that abuse of older people was understood and addressed. APEA's focus has and continues to be on preventative strategies and collaborative responses to financial abuse. Since its inception, APEA's achievements have been many and include statewide education sessions, presenting at many community forums, and state and national conferences. APEA has a range of resources, including videos and fact sheets that can be viewed and downloaded from their website, which is www.apea.org.au. Hard copies of resources can be sourced from the APEA agencies directly through you contacting that agency. Before we get started, we just have a few more housekeeping topics to cover. We invite your questions. Please look at the Q&A box on your screen. If you think of a question for your speakers at any point, just type it in there and I will pose it during the Q&A portion at the end of the webinar. If we do not get to your response to your question today due to time constraints, we will develop a FAQs or frequently asked questions, and we'll email that to all attendees with the recording. Please note you can also post your questions anonymously. There is a checkbox in the Q&A box that you can tick. ARIS wishes to remind participants to maintain self-care and follow any Australian government or any Department of Health or Emergency Management directions or guidelines to ensure you are appropriately social distancing if you are participating in the webinar with other individuals. So let's get started. I would like to introduce Doris Geoffrey from ARIS. Doris is the Operations Supervisor at ARIS. Doris is very passionate about the need to raise awareness of issues concerning older people and how they can protect their rights and safeguard their future. She also chairs APEA. With a degree in social science, Doris has worked endlessly in the aged care sector for nearly 20 years and sits on many committees and steering groups to ensure the voices of older people are heard. Over to you, Doris.
I always forget to unmute, sorry. Yes, my name is Doris Geoffrey and I'm currently the Operations Supervisor, and I've been with ARIS for almost 20 years, obviously in various roles. So let's get to it. Next slide, please, Sakina. Sakina, I don't have the notes. Sakina?
PowerPoint presentation, PDF.
Yeah,
Just start that.
yeah, okay. It's So I just want to say that the focus of my presentation today is to talk about safeguards to prevent financial abuse. ARIS is funded by the Australian Government Office for Ageing Well, SA Health and CODA Australia. ARIS is the South Australian member of the Commonwealth-funded Older Persons Advocacy Network, also known as OPAN. OPAN is made up of 9 community-based organisations, and there's one in each state and territory, and work together to deliver a free, nationally consistent advocacy, information and education services to older people across Australia. Next slide, please. So in regards to providing advocacy support, these are our key service areas and includes anyone who resides in residential aged care homes and retirement villages, those who are still living independently in their own homes and receiving aged care services, those who are abused by someone they should be able to trust, Navigator, which is led by CODA Australia, supporting people to connect to My Aged Care to access aged care services. We also have 2 Aboriginal advocates who provides advocacy support in a culturally sensitive manner across all of our key service areas. To be eligible for our service, 65 years and over or 50 years and over for Aboriginal and Torres Strait Islander people. Next slide, please. So the role of an advocate is to take the side of the older person and work at the direction of the client or their legal representative. So legal representative will also be included when I mention older people or client. Saves me having to repeat it. All matters are treated confidentially, of course, and only disclose information to other parties with the client's permission. So we will never work above the client. It's always by their side, the client's side, and always, we take direction from the client. So we do take the time to listen and understand the client's views and wishes. And we assist the client to explore their options to enable them to make an informed decision. So we also provide practical assistance. For example, support the client at an appointment with a legal service appointment or at SAPOL if the older person is needing to make a report at a police station. We then establish an action plan, which is in consultation with the client. So when it comes to talking with the client, we will actually visit them at their home. They can also ring ARIS and we can talk to them about the situation over the phone as well. Just also like to mention that all ARIS advocates are professionally qualified practitioners and have undergone police clearance. Next slide, please. The definition of elder abuse. Now, this is really important, so I think I will read it to you. So elder abuse can be defined as a single or repeated act or lack of appropriate action occurring within any relationship where there's an expectation of trust, which causes harm or distress to an older person. And as you can see, there are various forms of abuse and includes physical, sexual, psychological, financial, and or neglect. Now, in this definition, there are 2 major points that I would like to mention. Firstly, that an older person has been abused and has suffered injury, whether that is psychologically, physically, sexually, socially, neglect, or financially. The second point is in this definition is that another person or persons in a relationship of trust was responsible for causing or failing to prevent the harm. This relationship of trust, unfortunately, is usually by a family member, such as a son or a daughter. Therefore, any abuse by strangers is excluded from this definition. Next slide, please. I'm just going to now provide a very quick scenario of a situation. In this particular case, the son and her granddaughter moved into the older person's home after the breakdown of his marriage. After a while, the granddaughter, whom she had a very close relationship with, began asking the grandmother for money, and she also verbally abused her when her father wasn't present. She threatened her grandmother if she didn't give her the money, she would tell her father that she hits her. The granddaughter did have an enduring power of attorney. So after attending an ARIS community information session, the older person spoke to the advocate about her home situation with her granddaughter. She didn't want to tell her son in case he didn't believe her. The options that the advocate provided included counselling for the older person to cope with the situation with her granddaughter, revoke her granddaughter as her enduring power of attorney. She could appoint a trustee company if there was no one else that she could trust. It was decided that the older person needed to speak with her son about the granddaughter's behaviour. It turned out that the granddaughter was not coping with her father's marriage breakdown to her mother, and that the granddaughter also needed counselling. Also spoke to legal services in regards to the money that she gave her granddaughter, which was under pressure, whether she wanted it back or not. So the advocate, upon request, attended the appointment with the older person for support. She decided that she didn't want to pursue this as she wanted to maintain her relationship with her granddaughter. So in the end, there was a good outcome all round, and the older person was very happy that she continued to have a good relationship with her granddaughter. So just want to inform you about some key findings, and this was from the National Elder Abuse Prevalence Study, which was conducted by the Australian Institute of Family Studies. I will emphasise that prevalence rates reported are likely to be underestimated as older adults tend to underreport, in particular where there is intergenerational violence due to the shame and embarrassment that a son or a daughter had hurt them. So the National Elder Abuse Prevalence Study stated that 1 in every 6 people over the age of 65 years experienced abuse during the 12-month period. The most common forms of abuse was psychological, followed by neglect, financial, and physical. Most common alleged abusers were in fact adult children, followed by friends and neighbours. Unfortunately, this study also revealed that only a third of victims are seeking help from a third party. We will now compare these findings to what is reported to ARIS. Next slide, please, Sakina. So here we have the types of abuse that are reported to ARIS, and this was in the last financial year. So we find that psychological and financial are the most forms of abuse reported to us, compared to psychological and neglect reported recently in the Australian National Elder Abuse Prevalence Study. Next slide, please. I also want to add that when I first started at ARIS, which was back in 2002, the prevalence rate was 1 in 25 people who were experiencing some form of abuse. So that certainly has escalated. And who are the abusers? Adult children are reported as the main alleged abusers. In fact, it is estimated that 80% of the cases reported to ARIS are by immediate family members. That's pretty sad, isn't it, considering that these should be the people that, you trust the most. Adult children as the main abusers are consistent with the findings from the National Elder Abuse Prevalence Study. Next slide, please. So let's have a look at some of the risk factors. Risk for elder abuse includes all races, religion, ethnicities, culture, and socio-economic groups. So elder abuse certainly doesn't favour a particular religion or culture. So it affects everyone. Gender indicates that women are more likely than men to experience elder abuse. Poor physical health has been consistently associated with elder abuse, where older people are dependent on their adult children for care and transport to medical appointments. Other common risk factors include dementia, mental health issues for the older person or the abuser, or even both. Cognitive impairment or dementia have been found relatively high rates of mistreatment by carers. Isolation may be related to the death of a spouse and friends. There may also be some history of family conflict. So risk factors from the Prevalence study included lower socio-economic status, being single, separated or divorced, living in rented housing, owning a house with a debt against it, and poor physical or psychological health. Next slide, please. When it comes to safeguard, it is important to plan ahead and consider careful completion of appropriate documents, such as the advanced care directives and enduring power of attorney documents. On our website, you will find a resource that has been developed by APEA called Recipes for Living Well. If you give Aris a call, we can post these out to you if you can't download them from the website. Before signing any legal documents, please seek legal advice, as documents such as the enduring power of attorney can be used against you if it is not done correctly. So I won't talk too much about this now, because we do have Legal Services Commission who can provide you more information on those legal documents. Next slide, please. However, Aris does promote safeguards. We encourage people to plan for the future. Consider making advanced care directives during power of attorney and ensure that your will is up to date with any changes in your life. That is so important. Decide on your preference and let others know of your decisions. In particular, provide your GP with a certified copy of your advanced care directive, as well as your bank manager with a certified copy of your enduring power of attorney. Your GP and bank need to know who is acting in your best interest if you are no longer able to make those decisions. The other safeguard that we would talk about when people call us is remain active in the community. So maintain your social contacts, develop friendships outside your immediate family. Be involved with community activities. Isolation can increase an older person's vulnerability. Also, be as independent as possible. Take care of your own health by eating healthy and keep up with your regular health checks with your GP. Ask for help from services when required so that you are less dependent on your family members. Think carefully before accepting personal care in exchange for your possessions or accommodation. And finally, plan to be safe and feel safe in your own home. So consider ringing St. Paul Home Assist, who will do a free safety audit check of your home. So they will come over and check your windows, check your outside lighting, check your security doors. Next slide, please. If you are experiencing abuse or know of someone who is at risk or imminent harm, you can contact the South Australian Adult Safeguarding Unit, who have investigative powers. Reporting suspected or actual abuse to the South Australian Adult Safeguarding Unit is voluntary. The Adult Safeguarding Unit is a state government initiative under Office for Ageing Well, SA Health, and commenced in October 2019. Next slide, please. So if you wish to give us a call or send us an email in regards to any situation that your own situation or someone that you know who may be experiencing abuse or is at risk of experiencing abuse, please contact Aris, and these are our contact details. Brochures, we also have brochures in other languages, which are also available on our website. So for further information about our service, can also be found by visiting our website. Thank you.
Thank you, Doris. I just wanted to make a comment around some work that ARIS is also doing nationally. So recently, ARIS attended the National Elder Abuse Conference in Tasmania, and there was a subsequent workshop which was held for community leaders and older people as part of our ongoing support for Elder Abuse Action Australia as well. The purpose of that workshop was harnessing member and community views, which include information to discuss with government, such as what is the plan for the next national plan to address elder abuse. So this information is currently being collated and will be put into an action plan to inform discussions with the government. So our next presentation is by the public trustee, and they are unable to be with us physically today, but have sent us a pre-recorded presentation. Can we please share the presentation, please? Thank you.
Hello, my name is Marcel Confe, and I'm a team leader within the Personal Estate section of Public Trustee. Public Trustee is proud to be a member of the Alliance for the Prevention of Elder Abuse, and we thank you for giving us the opportunity to speak at today's webinar. I've pre-recorded this presentation as I'm not able to attend in person today. Should you have any questions or would like to discuss anything further that I've raised, please direct them to the webinar coordinator, who'll be happy to forward them through to me. You're also welcome to contact me at Public Trustee, and the contact number will be available at the end of this presentation. I'm now going to share my slideshow with you. So today I'll be giving you an overview of the functions of the Personal Estates branch within Public Trustee, especially where Public Trustee are appointed as financial administrators to protect vulnerable South Australians and their finances from financial abuse. Public Trustee is a long-standing and well-respected institution that has delivered an essential service to thousands of South Australians for over 140 years. We currently handle the financial affairs of more than 4,000 South Australians, many of whom are not able to manage their own finances. We also administer some 1,700 deceased estates and manage 3,000 trusts. Many of our customers are the most vulnerable members of our society, and we take our role and responsibilities seriously. Public Trustee does not make health or lifestyle decisions for our personal estates customers, although the consequences of some of our financial decisions will enhance a person's lifestyle. The responsibility of our health and lifestyle decisions may rest with the person themselves, another responsible person, a guardian, or the public advocate. So what does Public Trustee do? We continue to provide core trust services of wills, deceased administration, and personal estate administration. We also provide other services that support our core business, including taxation services and funds management. We also provide an examinations or regulatory role in relation to private administration, where someone has died without a will, or overseeing private administrating acting under the South Australian Civil Administrative Tribunal, which we refer to as SACAT. This was formerly the Guardianship Board. Public Trustee also provides general information in relation to trustee products and services to the people of South Australia via telephone, letter, our website, and talks such as this today. Now, the personal estate section of Public Trustee has approximately 4,000 customers pursuant to administration orders. We also have customers under enduring power of attorney and under court orders under the Aged and Infirm Persons Act. There are approximately 70 staff divided into 5 teams. The administration order is an order made by SACAT that appoints an administrator to make a financial decision for a person with a mental incapacity. A person under administration order is called a protected person. A guardianship order is made by SACAT that appoints a guardian to make lifestyle and medical treatment decisions for a person with a mental incapacity. SACAT will only make this order when it is satisfied that the person is unable to manage their own financial affairs because of a mental incapacity. In deciding who should be appointed, SACAT must consider the wishes of the person, both past and future, and if those wishes can be established with some supporting information, whether there are any financial arrangements or relationships that should not be disturbed, whether the proposed administrator is readily available and competent to perform the role, and whether there would be any conflict of interest arising from the appointment. As an administrator, Public Trustee is legally responsible for making all or some of the protected person's financial and legal decisions. This includes decisions about the protected person's income and property. The administrator will collect income, including Centrelink income, payment of accounts, and establish and review their budgets. They may also pay entry contributions to nursing homes, purchase motor vehicles, furniture, and negotiate with creditors. The administrator is accountable as a trustee in relation to the protected estate. The administrator may also take into account the legislative principles which are contained in Section 5 of the Guardianship and Administration Act, which are the principles intended, well, the spirit of the legislation in the decision-making process, which we call substitution of judgment. What is the wishes of the person would they have not been mentally incapacitated? What are their present wishes? Whether or not existing informal arrangements for the treatment and care of the person are adequate or should not be disturbed, and decisions made should be the least restrictive of the person's right and personal autonomy, while still ensuring the person of their proper care and protection. When the authority of appointment or the order from SACAT, the order from the court or an enduring power of attorney is received, the file is allocated to a new estates officer. I'm the team leader of that team. And that team will write to all initial letters, to all initial letters to interested parties and stakeholders, interview customers, liaison people, identify assets and liabilities, and set up an initial budget for payments and collect and secure all assets, property, bank accounts, income and the like. After a period of about 3 months, the file is allocated to a maintenance officer based on the complexity of the case. Personal estates maintenance officer will review the file at handover and establish relationships with the customer and the liaison person. The budget is reviewed and any adjustments are made and an investment strategy is established. The maintenance officer receives and considers requests for funds from the customer, their liaison person, or their social worker. As set out above, there are legislative requirements, policies, and procedures that guide the officer in relation to exercising substituted judgment. The officer must consider the request within the parameters of the legislation and Public Trustees' policies and procedures. Insurances and property maintenance are important aspects of case management, and customers' files are reviewed annually. Also, at any time that a personal estate officer has a concern for our customers' welfare, we will ensure that we refer matters to external parties to render assistance. We work in collaboration with the Office of the Public Advocate, and ensure any matters of concern are referred to the Adult Safeguarding Unit or any other agencies that are required for intervention. So I'll give you an example of a case study. A new estates officer recently received a new matter from SACAT for an elderly customer who was in a residential facility and no longer had capacity. The matter was referred to SACAT initially by the residential facility, who advised that they were no longer receiving payment for their daily care. Public trustee were appointed as there was evidence that a family member, who was their power of attorney, was potentially misappropriating the person's funds. They had direct access to their bank accounts and were withdrawing large sums of money and failing to make regular payments for the person's care. Upon being appointed by SACAT, Public Trustee wrote to the person's bank and removed all third-party access. The SACAT order also gave us authority to rescind or stop the power of attorney instrument, and we diverted all Centrelink entitlements to the Public Trustee to commence administrating the person's finances. We referred the matter to our legal team, and this was referred to the Crown Solicitor's Office. We also obtained evidence from the bank to prove that our customers' finances were misappropriated. We were able to set up payment arrangements with the residential facility and ultimately secured their accommodation on an ongoing basis. This matter does remain under investigation. However, our customer is no longer at threat of being evicted from their care facility, and their day-to-day needs are now being met. So, in summary, Public Trustee is not only a long-established maker of wills and power of attorney, we are a complex, modern organisation that manages people's financial affairs because they cannot do it themselves. We've ministered to deceased estates, having been appointed executor of the estate in a will or under the laws of intestacy. We manage trusts and investments, and we provide general trustee services to the people of South Australia. So I'll just leave this slide up for a moment so you can refer to the contact details if you wish to contact me. There are also some links to our website, to SACAT's website, where applications can be made for administrators, and also a link to the Office of the Public Advocate, who I believe will be speaking to you separately today. Okay,
Thank you so much.
Stop sharing this slide to you. I would now like to thank you for the opportunity to show you how Public Trustee is here to protect vulnerable South Australians from financial abuse. Have a good day.
Thank you so much for that presentation. It's most welcome. Our next speaker is Detective Sergeant Sam George from SAPOL. Detective Sergeant George is an investigation supervisor at the Cybercrime Investigation Section and has been with SAPOL for 36 years. In addition to police station and country police duties, Detective Sergeant George has been with the Criminal Investigation Branch in the suburbs and is currently within the Cybercrime Investigation Section, which is part of the Financial and Cybercrime Investigation Branch. As you can appreciate, the nature of Detective Sergeant George's work will mean that this presentation will not be sharing the camera. Thank you so much.
Good morning, everyone, and welcome to this presentation. This is just a brief synopsis about some remote access investment scams and some precautionary measures to take into account. I'm sure that there will be some questions that will be asked of us at a later time. If we can't answer them after this session, then obviously we can get back to you in relation to those questions. Can I have the next slide, please? Okay, you can see from statistics, and we'll very briefly go through these, but these are statistics that are captured to give us a scope of what's been going on in the last few years. You could probably appreciate that the level of criminality has increased, and that's got it's in relation to a majority of different factors that we can take into consideration, and that could be the internet usage by people working from home more often during this pandemic. It could be an uptake of technology and people being educated in the use of this type of technology for ease of use in relation to such things as your banking, your bill paying, etc. But as you can see from these statistics, in 2021, there were over around 2,000 South Australian victims of scams, which was a 26% increase from the previous year. And what we're actually seeing is an increase as years go on. Hopefully, with education and the likes, we can see a decrease in that when people become more familiar with the types of scams that are going on, because it's a lot easier to prevent it than to investigate these scams. As you can see, investment in romance scams saw a 182% increase, which is a ridiculous amount. There's been a combined nearly 20 million lost from investment and remote access scams, and I'll go into detail about what those remote and access scams actually involve. The average age of victims for remote access scams this year alone is 60 years, with an average loss about 12,000, and that is quite deceiving because we've had some people that have lost just in the tens of dollars, whereas others have lost in the hundreds of thousands of dollars. Can I have the next slide, please? So what is a remote access scam? Briefly, the crooks actually use a number of different tactics to get the trust of people who they try and contact. There's the scam, there's the call outs with urgent issues, like cold phone calls as we call them, and they are phone calls that you're not expecting, but someone actually rings you up in relation to that. There's installation of software on your computer system as a result of that, and they'll attempt by all means to keep you on the phone, just so that they can gain your confidence and get you to do things that you wouldn't ordinarily do. But as you can see from there, the type of software that we're talking about that they install on the computers is AnyDesk, Quick Support, Assist Client, and the most common one that's used is TeamViewer. We actually use TeamViewer at work when we have our information technology people that need to remote access into our computers to rectify a problem. So all these are actually legitimate software, but the crooks use them for illegitimate purposes. Can I have the next slide, please? All right, so steps we have to be taken, and everyone just needs to know that they can target, and I'm talking about crooks, these miscreants can target any person, okay? No one's safe. So the main thing to be aware of is we have to be aware. We have to be aware of any calls or any unexpected conversations that people are requiring of you. And that's what we need to be careful of, because they rely on the scammers, that is, they rely on people's fears to obtain and deceive you. People would have heard about the tax office being in touch, and if you don't pay an outstanding fee, they'll come around and arrest you. Likewise with the police departments, they say that you've got an outstanding fine, or there's arrears of payments that you need to make, and if you don't do that, you'll be arrested. All these type of things are scare tactics, and they prey on people's fears to get them to abide by what they want them to do, and that's to deceive them out of money. Law enforcement agencies will not contact you and ask you to make payment. The tax office will not contact you by phone and ask you to make payments. So these are the type of things that we have to be careful of. Software updates on your computer and your mobile devices, like your tablets and your smartphones. It's very, very important that these take place, because all these software and devices have vulnerabilities that get recognized by the manufacturers. I'm sure people that use Microsoft are aware as in with the Windows updates that come frequently. That's because Microsoft have found vulnerabilities in the software and they patch it so that the crooks don't take advantage of this software, find loopholes in your programs and get into your systems. All right, so you've got to be careful. You've got to protect your details at all costs. So don't share your details. You don't need to. The only people that you should share your details with are maybe close family friends that, close family members who can keep tabs of some of your personal information in the event that they get lost or you forget them or something similar. And you just don't give it out willy-nilly. You've got to be very, very careful with what you distribute and what details you share with others. And the important thing is, I know the slide says never give remote access. You've got to be careful about providing anyone with remote access to your devices. I said before that the software is actually legitimate for legitimate purposes. Be mindful of who you're giving that remote access to. If at all possible, you initiate the remote access. In other words, if you have a problem, for example, Microsoft had to actually remote access into my home computer to rectify a problem, but I actually initiated that. It wasn't through them ringing me and telling me that there was a problem with my computer. I told them that there was a problem and they needed to fix it up. Next slide, please. Okay, so we're talking about investment scams. And the setup with that is there's unexpected contact from social media, emails, text, phone, and even adverts. And what they promise you is unrealistic returns or really like quick returns. A lot of these scammers try and utilize similar names to legitimate companies as well. You've got to be careful of those. There are steps that you could take to actually identify whether a company is legitimate or not, and you can check that via ABNs and government websites through ASIC, etc., to identify if there are legitimate sites. The other thing that you really need to do as well is do your homework. There are the likes of ScamWatch and other government-related websites that you can go onto to find out if people have legitimately invested in companies and made returns, and those that have actually scammed people, and so you can stay well clear of them. But don't forget, these are always evolving, and because they're not listed as scam sites, it doesn't necessarily mean that they aren't, because it could be that they're a new site and people have not become aware that they have been scammed yet. All right, can we just, yep, that's it. Sorry, could we just go back a step? There's a couple of points that I missed out there. All right. The other thing is the slick websites. These people are scammers, but make no mistake, this is their full-time employment. So they're actually doing it regularly. This is their regular income, is by scamming people out of money. All right, so they appear legitimate, but as I said, check out the fake credentials on the ASIC sites and see if they've actually been endorsed. The dating apps, you have to be really, really careful about those dating apps, because people that are actually using those dating apps are quite vulnerable. They're seeking love, and they're prepared to believe what people are telling them. And unfortunately, the crooks are aware of this, and they will take advantage of people's vulnerabilities and scam them out of money. So you have to be really careful about those type of apps, and even people that you know that are utilizing them. warn them, like, is it realistic that this person wants a relationship or wants to meet up? Why are they asking for money? And they will give you a Mills and Boom story to try and get money out of you. They've got kids that need operations, they've got sick family members, or they've had an injury or something and they need to have an operation so that they can get fixed up and come and visit you. The likes of those type of things. Or they haven't got money to be able to buy a plane ticket to come and visit. Those things need to be really carefully considered before making any payments to anyone. Paid advertisements, ads across web offering ludicrous returns, and that's part and parcel of the investment scams, and fake news articles, which is pretty well self-explanatory. Can I have the next slide, please? Okay, so we've basically covered most of them. Quick and easy investment returns, sometimes tax-free benefits, investment in shares, cryptocurrency. That we're seeing a really big trend in cryptocurrency frauds now, where people are actually are being asked to invest in cryptocurrency for large returns. Unless you actually know the product and unless you're very familiar with the type of investment you're considering, don't take part in it. And again, revert back to what I said before about doing your homework. You initiate the contact. So if someone calls you, don't worry about it. Don't make any promises. Don't initiate anything with them. If there's an offering via the website, don't click on any links, and don't rely on information that they're providing you. You have to do your own research and find out the legitimacy of those businesses before you interact with them. Inside information on initial public offerings or discounts. These are some of the warning signs. Okay, so just be wary of the factors that an opportunity with no risk or low risk, because you will be able to sell any time, get a refund on non-performance, have insurance guaranteed transaction, be able to swap investments for another. These are all the type of tactics that they use to try and, for a better word, suck you in to departing with your hard-earned money. And at the end of the day, all they're doing is scamming you. Can I have the next slide, please? Okay. So this basically covers what I said before. Ask questions and request information. So don't be afraid to ask questions. And if you're not happy with any of the information, research it. Even if you think you're happy with the information, still jot down. Don't make any rash decisions until you've had an opportunity to research it. Do your own research as well, and don't rely on them to provide you with that information. Don't just use the website to check the information. Okay. Make contact with government agencies to find out if they are legitimate websites and legitimate businesses. And if it doesn't feel right, then do not go with it. And again, the old adage is, if it's too good to be true, then most likely it isn't true. Okay. Can we go to the next slide, please? Okay, so asking questions and requesting info. Again, what we're doing here is covering it. We can't what's the word I'm looking for? We can't be more direct with you into trying and doing these things. We have to actually drum it into people to be very careful and ask all these questions. Again, it can be investments in relation to crypto, mortgage, real estate. I think we went backwards. Yeah, so the type of questions we can ask is, what's your name? What's the company represent? Who owns the company? Does your company have the legitimate licenses that we require? What's your address? and ask for reference numbers as well, so you can actually go onto and find out the different companies, and when you refer back to a reference number, they should be able to have all that information for you. Okay, the kind of scams that we're seeing and the trends, threats to arrest, the remote access where people are actually using the software to gain access to all your credentials. Not only can they actually rip off the information and scam you out of money, but they can actually still go into your computer at a later time and access this information and keep on offending. There's business email compromises where it's a go-between, and they actually intercept emails and pretend they're a person that they're not, with the intention of actually intercepting emails for money payments and redirecting those payments to a fraudulent bank account. The investment scams and the romance scams, as I said before. So can we have the next slide, please?
So unfortunately, thank you, Detective Sergeant George. Unfortunately, due to time, I'm going to have to cut this short, but I'm sure you would be willing to share this presentation with our viewers. It's really, really fascinating and interesting, and I'm really fascinated given that I'm heading towards that age group of the average person. Thank you so much for your presentation, but unfortunately, due to time, we might need to move on to our next presentation.
Sure. Just on finishing up, if people can just take note of those websites, they are a really good reference so that they can do their checks or make any reports. Thank you very much for your attendance.
Thank you so much. Now I'd like to move to our next speaker, which is Elise Sullivan from the Legal Services Commission of South Australia. Elise has been a member of APEA since 2015. Elise is a solicitor working with the Legal Services Commission in its administrative law group. Elise's current work has been a particular focus on working with older people who are subject to guardianship and administration orders made by SACAT. Very interested to hear about that, Elise. And Elise is certainly an expert and has presented at a number of seminars, webinars and conferences on the topics of elder abuse, advanced care directives and enduring powers of attorney and wills. So thank you, Elise.
Thanks, Caroline, for that introduction, and it's fantastic to be here with you today to talk to you about some safeguards to prevent elder abuse. As Caroline said, my name is Elise Sullivan and I'm a solicitor with the Legal Services Commission. Thanks, Kina. I'd just like to quickly also do an acknowledgement of country and acknowledge the traditional owners of the lands upon which we're meeting today. I'm coming to you from Paramount country in my home in the Adelaide Hills, and I pay my respect to elders past, present and emerging, and extend that respect also to any Aboriginal attendees today. Thank you. So today, I'm going to talk about this topic of safeguards to prevent elder abuse from a legal point of view, exploring how safeguards might be utilised with the use of legal documents, and in particular focusing on enduring powers of attorney. I'll provide you with a financial abuse case study, which will explore some of these issues. And I'll also tell you how you may be able to obtain some free legal advice so that you can be supported if you have any concerns regarding elder abuse or financial elder abuse. Thank you. So for all of us, there may come a time when we need to depend upon others to provide care to us. And it's at this time that legal documents can be used to ensure that we still have a voice and that our wishes are upheld. And the legal documents that come into play at this time are advanced care directives, enduring powers of attorney and wills. And today, because of time constraints, I'm only going to be looking at enduring powers of attorney. Thank you. So enduring power of attorney is a legal document that allows you to appoint one or more people to manage your financial and legal affairs. It's a document that is usually activated when you are unable to manage your own finances and when you lose what's called legal capacity. In the document, it goes without saying that the person or people who you appoint should be someone who you trust. Thank you. So how does an enduring power of attorney act as a safeguard to prevent financial elder abuse? The first, I suppose, point to make is if you draft an enduring power of attorney carefully and you ensure that you've appointed a person you trust, you're taking steps now to put something in place so that someone who you trust is going to act on your behalf in the future. It's possible to include in an enduring power of attorney specific conditions that might relate to how your money or your assets are managed. For example, you might put a restriction or limitation on the way that a person can, your appointed attorney can deal with a particular asset. You might be able to limit the way that they can sell your property, for example. Or you might be able to put a condition in place that might require your finances and your accounts to be independently audited every 12 months by an accountant. And these are just some examples of some of the things that can be put into a power of attorney that might help to safeguard you down the track. You can also update an enduring power of attorney when your circumstances change, and we definitely recommend that everyone regularly reviews their power of attorney to make sure it reflects their current wishes. So when drafted carefully, an enduring power of attorney can be a safeguard, but it's really important that advice is sought before an enduring power of attorney is drafted, and assistance is also sought if support is needed in the drafting process as well. And I've mentioned there on the screen that if in doubt, seek legal advice through the legal helpline, which my office runs, which is a free legal helpline, and the contact number 1300 366 424. And I'll come to that in a bit more detail later on as well. Thanks, Kina. So what happens if an enduring power of attorney is misused? So I've spoken about how an enduring power of attorney can be used as a safeguard. Unfortunately, what we quite often see is that an enduring power of attorney can actually be misused and be used as a tool to perpetrate financial elder abuse. So this might look like someone misusing your money or your assets without your consent, or in a way that you didn't envisage them to be using. It might look like someone making you feel like you can't manage your money yourself anymore when you think that you can. It might look like someone using your money and their power in an enduring power of attorney to buy things for themselves. It might look like someone threatening to do something specific if you don't provide them with money. And the perhaps classic example is saying to someone, if you don't provide me with money or this asset or do this particular thing, then I won't let you see your grandchildren. Thanks, Kina. So I'll provide a bit of a case study on a client that came to my office at the Legal Services Commission, and we've obviously changed his name and details. John is 80 years old and he lives independently in his own home. And he has 3 children, 2 daughters and 1 son. His son comes over one day and says, "Dad, I've got a document for you to sign here. I filled it all out. You don't need to worry about it, but it's time that I took over and I helped with your money." John thinks it's a bit strange because he's quite independent and still capable, but his son is very insistent and persistent. And so he agrees to go with his son to the local library to sign the enduring power of attorney in front of a justice of the peace. He doesn't want to rock the boat. Once the document's signed, John's son takes it straight away, doesn't give him a copy, and demands that he immediately hand over his bank cards and access to all his bank accounts. And he says again, "Don't worry, Dad, I'm looking after things now. You don't need to worry about anything." The very next day, John's son withdraws $5,000 from John's bank account and uses it to buy himself a new car. He was able to withdraw that money because he took the completed enduring power of attorney into the bank as evidence to say, "John's given me permission to do this." Next slide, thanks. When John finds out that he's had the $5,000 transaction, he calls the bank immediately and they're unable to assist him. He then tells his daughters what have happened and they suggest that he seeks legal advice. John calls the Legal Services Commission on the free legal helpline of 1300 366 424 and he speaks to a lawyer for free. The lawyer recommends that he comes in for a free appointment with a lawyer to discuss what they can do. So John comes into our office at the Legal Services Commission and he has a free appointment with a solicitor. The lawyer helps him in that appointment to immediately revoke the power of attorney that appoints his son, because John doesn't want his son acting in that role anymore. The lawyer advises him of how he can make a new enduring power of attorney if that's what he wants to do. The lawyer takes him through some of the safeguards and limitations that he can put into an enduring power of attorney if he decides to make a new one. And those are perhaps some of the examples that I gave previously. The lawyer also gives him advice on how he can recover the $5,000 that was taken from him by his son. Thanks. Next slide. So from this legal advice appointment and by reaching out and requesting that legal advice, John now has a better understanding of what an enduring power of attorney is and how he can draft one that might protect his interests and include some of those really important safeguards that I've mentioned. He also appreciates that if something goes wrong, he can revoke the document. So just because he decided at the time to appoint his son in that role, when his circumstances change, he can take steps to revoke it, which he did do. Ultimately, John might not decide to draft another enduring power of attorney, and that's his choice. But the main thing is that he now has the information that he needs to make an informed choice. It's also important to note that through obtaining that legal advice, John has been empowered into taking some proactive steps to try to limit the financial advantage that his son was taking of him. Thanks, Sakina. So from this case study that I've given you, you can hopefully see the importance of seeking legal advice at any stage when you're considering drafting an enduring power of attorney, to understand these documents, or if something goes wrong with these documents once they've been made. So my office can provide you with free legal advice, and the best way to contact us is via our free telephone legal helpline, 1300 366 424. That telephone helpline operates Monday to Friday from 9 AM to 4:30 PM. And when you call the helpline, you get straight through to a solicitor. So you're getting that immediate free legal advice. And from that initial conversation, if an appointment is recommended, then the solicitor will advise you on how to arrange that. Thank you. Next slide. So that's a very quick overview of some financial elder abuse concerns, including how it relates to enduring powers of attorney. And as I've mentioned, please do call us on the free legal helpline for any individual circumstances. And if you have any questions arising from today, please pop them in the chat box and we'll try to address them in the Q&A portion at the end. Thank you.
Thanks so much, Elise. Very informative and fantastic work that you're doing. Our next speaker, or final speaker for the webinar today, is Kate Jensen, who works as a manager, dispute resolution, education, information and customer service at the Office of the Public Advocate. Kate is the manager of dispute resolution, information and customer services at the APEA. Kate has a legal background and many years' experience mediating in many fields, including family, older persons and human rights. Thanks so much for participating. Over to you now, Kate.
Hi everyone. I'm Kate. I will, in the interest of time, do a much briefer presentation than I originally thought, so that I can leave questions for people. So, the Office of the Public Advocate. Next slide, thanks, Sakina. Thank you. And next one. Thank you. So the role of the Office of the Public Advocate is to promote the rights of people with impaired decision-making capacity. And our Public Advocate is an independent statutory officer accountable to South Australian Parliament and appointed for 5 terms. And our Public Advocate, Anne Gale, has just gone into it's about 18 months into her second term. Next slide. And next slide. I won't bore you with the legislation. Yeah. So the Office of the Public Advocate does a lot of different functions working in this space of assisting people with impaired decision-making capacity. And the space of decision-making capacity is really the space that we work in. And today, so some of our functions there, we do information sessions like we're doing now, and we provide an information service as well for people to ring up and ask questions in this space around impaired decision making and what they can do if they're worried about someone who has difficulty making decisions. We provide dispute resolution, and I'm going to talk about that function particularly in a minute. And also we can be appointed as guardian to assist people to make decisions when they're not able to, as an option of last resort. We can also be asked by the South Australian Civil and Administrative Tribunal to investigate matters. And we provide advocacy, mostly systemic advocacy. But the 2 functions I'm going to really talk about today are our dispute resolution service function and our guardianship function, because I think they're probably most relevant. Because the space we work in, as I say, is, we'll skip that one. Thanks, Sakina. The space that we work in is a decision-making space. So is someone able to make decisions themselves about their healthcare, their lifestyle and their accommodation? So we work in that space. If they are able to make those decisions, then they can make an advance care directive and appoint some substitute decision makers to assist with make those decisions for a time when they're not able to make those decisions. If they aren't able to make those decisions, then we can be appointed as guardian to assist them to make those decisions. I think there's been a recent shift in the concept of decision-making capacity over the years, and it's more rights-based, based on person's wishes and what they would have wanted. And we're trying to support people to make decisions now rather than substitute decisions, and we presume capacity. But I think that shift is in some of the newer legislation, in the Advanced Care Directive Act and the Consent to Medical Treatment Act. So next slide, Sakina. Whereas, next slide, sorry, I'm trying to rush through to get to, and next slide. Yeah, so when someone doesn't have the capacity to make their decisions around their healthcare, lifestyle or accommodation, the South Australian Civil and Administrative Tribunal can appoint us to make those decisions, to appoint the public advocate to make those decisions. What you need in order to go to the South Australian Civil and Administrative Tribunal is you need medical evidence that the person has an impaired decision-making capacity and that there's a current and specific decision that needs to be made. There's no advance care directive in place and there isn't anyone appropriate to make those decisions. Then SACAT can appoint the Office of the Public Advocate to make those decisions. So an example of that might be somebody who needs to move into an aged care facility and they don't have any family, or their family aren't making choices that are the right choices for them. They have an impaired decision-making capacity and they can't make that decision. And an application would be made to SACAT and the Office of the Public Advocate would be appointed to make that decision. Next slide, Sakina. And next slide. Yep, and next one, sorry. Okay, so, yep, and again, sorry, I did send through a shorter presentation, but it didn't get there on time. So when we're appointed to make decisions, we can be appointed to make accommodation decisions, lifestyle decisions, or healthcare decisions. And so once we're appointed, we take on that responsibility to assist that person to make those decisions. And next one. We must follow principles in the Guardianship Administration Act when we're making those decisions as guardian for somebody. We must look at their past and present wishes. We must make the least restrictive option available, and we must balance that with the person's care and protection. We must also look to see if there's any current informal arrangements in place. And if there are, then we need to make the decision to keep that in place if we can, if it's safe for that person to keep that in place. And next one. So that's our guardianship function, and probably the main one. We have about 1,600 clients at the Office of the Public Advocate where we are making decisions for those people when they're not able to make those decisions for themselves or they don't have anyone appropriate to make those decisions for them. The other service that we offer is our dispute resolution service. And that's where we get that legislative authority under the Advance Care Directive Act. So if somebody, and the Consent to Medical Treatment Act. So if somebody has made an advance care directive and appointed substitute decision makers, and that's where they have capacity to make those, to make that document, that legal document. If there's any conflict in that space, someone can make an application to our office for us to look at resolving that conflict. So an example of that, we'll go to the aged care facility example again, is a client has made an advance care directive and appointed one of her children to make decisions for a time when she might not be capable of making those decisions. Mum's in the aged care facility. The sibling who has been appointed to make those decisions has conflict with her brother and isn't letting her mum see her son because of her conflict. So that comes to us and we have a look at that and we talk to the substitute decision maker about how she's supposed to make those decisions. She's supposed to step into the shoes of the person who made the advance care directive and appointed her and make the decisions as she would have made it. So mum doesn't have any conflict with her son. The conflict is between the daughter and the son. So the son should be able to see mum at the aged care facility. So we resolve that conflict through a number of different ways. We can provide preliminary information about the legislation and just the role and responsibility of a substitute decision maker. If that doesn't resolve the conflict, we can go to a more formal process, which is like a mediation, where we actually sit around the table. At the moment, it's on Zoom or Teams, listen to all of the different perspectives of the parties and try and resolve the conflict that way. We can also resolve conflict under the Consent to Medical Treatment and Palliative Care Act, but I won't go into that today. So these are the two main functions I thought, and I rushed through really quickly because I was really concerned about time and making sure there were questions, there was time left for questions, that the Office of the Public Advocate can assist people with impaired decision-making capacity. Thank you.
Thank you so much, Kate. You did an awesome job with all of that information condensed. And you know, it was always the trick of trying to manage timing issues and with technology as well. I have spoken briefly offline to Sakina to say, can we extend for 10 minutes past our deadline for questions? Hopefully most of the panelists can stay with us for that if possible. So I'm going to kick off. We had questions submitted to us at registration, and I'll try and work my way through those, but if we can't answer all of those questions, we will certainly endeavour to seek answers to all of those questions when we distribute the recordings and other information. So everyone, hopefully we can answer all of these diabolical difficult issues that come up at times. So first question is, can a carer in South Australia also be an enduring power of attorney? And I would suggest it'd be useful if we can also distinguish between a care worker and a carer. And I'm going to throw that one to Elise from the Legal Services Commission.
Thanks, Caroline. And look, I think it's a really good question. And I think we do need to distinguish when we talk about a carer in terms of a person who's in a paid role compared to a carer who might be, for example, a husband and wife, and one is providing care to the other. So in any legal documents, there may be restrictions on who can be appointed in particular roles. And the legislation or our law would identify if there are people who can't, from a legal point of view, be in those roles. In South Australia at the moment, our enduring power of attorney legislation doesn't prohibit particular people, although that's currently under review. But I would certainly say that there would be a possibility that there could be conflicts of interest that could arise. And you can see, particularly if someone's acting in a paid role where they're paid to provide care to someone, but then also looking after their money and making financial decisions, that could create some challenges. And I think it's really important that in each individual circumstance, again, people seek legal advice if they're concerned about that question, or they're not sure about whether the person they want to appoint might be best for them. So short answer is seek legal advice to address any concerns about conflicts.
Thanks, Elise. I'm open to any other comments before we move to the next question from any of the panelists, if anyone wants to add anything to that. Okay, we'll move to the next question. How to talk to family without hurting them, and how to say no without feeling guilty. I think that's a really interesting question, and I'm actually going to throw that to Doris at this moment. Thanks, Doris. You're on mute, Doris.
I always forget, don't I? Sorry. Look, taking a stand to say no is actually empowering. So, and you're looking after your own health and well-being. So if you do struggle to say no, think about why you are saying no. Say, for example, if, you know, your son has asked you for money quite often, so you need to say, you know, why do you keep asking for money? I really, you already owe me about $1,000 and you haven't returned it, so I just can't continue doing this. You know, I'm on a pension now, I'm on my own, and I need to look after my own future and use the money for my you know, services or aged care services that I need in the future. So I think it's really important to sit down and have that conversation with your son or daughter, whoever it may be, and you know, and perhaps ask, you know, why do they need the money? You know, if it happens on a regular basis. So, you know, are there any drug problems, or, you know, is there alcohol involved, or, you know, so why do they actually need the money? And they may need to perhaps be referred to a financial advisor to try and sort out their own issues. But we can certainly support the older person and meet with the older person and discuss some of the, you know, safeguarding strategies. You know, perhaps, you know, talk about putting in place an enduring power of attorney. And obviously she can't actually appoint her son who's been financially abusing her. So she may need, if there's nobody else that she has that she could trust, then she may need to perhaps look at a trustee company. So it's important that, you know, she needs to plan for her future. I think that's it, Caroline.
Thank you. I was just doing my unmute as well. It's a great unmute. The next question that we have is best practice to safeguard against elder abuse during verbal over the phone consultations. So this is for SAPOL, if possible.
Yes, thanks, Caroline. We were talking about, it sort of led on from what Sam spoke about before in his presentation. Look, if it doesn't feel right, and particularly if it's a cold call, don't necessarily feel pressured into, and I know we all find it sometimes hard to say no, especially when, you know, things sound good and they sound like they know what they're talking about. If it doesn't feel right and it's a cold call out of the blue, look, ask for a reference number and say, I'm not happy to make a decision over the phone. You can still be polite and say, I'd like to talk about it with other family and friends first. And even though they might give you a phone number to call them back on, don't necessarily rely on that number if you do hang up and want to call them back. Like Sam was saying, you know, do some of your own research if it's possible. Like yellow pages are still available and some white pages are still available. And before you ring them back, talk to family and friends. You know, find out about their experiences. Have they received calls like this before? And then if you feel comfortable and, you know, then call them back and say, look, I've got a reference number. This is who I spoke to before, and go that way to try and help, you know, safeguard it. If, you know, and if the person is pressuring you and they want you to try and, they're trying to lead you down to a response, and they're not actually dealing with the issue that you may have, even if you have called them yourself, you don't have to just be happy with the response that they have given you as well. You know, you can be polite and say, well, you know, I'd like a second opinion. I will call you back. And if they're not happy with it, then you sort of know, like you can trust your gut feeling and go, well, okay, they are trying to lead me, you know, down the wrong path, and it wasn't the right way to go. So, but the more you talk about it with family and friends, the better, you know, it spreads that information out, and the more people who know, the less likely them themselves and their friends and family to become victims. So yeah, just don't rely on the information that the person, you know, is saying that they're from, you know, and the company and things like that. So
thank you so much.
Yeah, because we tend to feel, you know, feel pressured, and we do feel guilty because we think, oh, this person has rung me for a particular reason, or I've rung them for a particular reason. But you do have the right to, you know, question things, and you can still do that in a polite manner. And if you're still not happy, please just ask more questions or hang up after you get a reference number, and, you know, call back if you need to. Yeah, and take your time. Don't feel rushed. The more rushed you feel, the more likely you are to become a victim of a, you know, scam or something, you know, something else as well. So yeah, the more they rush you, the more that should raise a flag in itself.
Thank you. Next question is, can a priest or chaplain be an executor on a, and I'm just reading the questions directed to us. Can a priest or a chaplain be an executor on a client/parish parishioner / resident's will, or is this a conflict of interest? I'm going to throw this to Elise.
Thanks, Caroline. Look, I think the answer to this question is probably very similar to my answer before with enduring powers of attorney, in that there might be some legislative provisions that prevent certain people from acting as executors. But even if there's not, you'd have to question whether it's appropriate and could create that conflict of interest situation. And I think that could certainly be the case if the priest was also, you know, standing to benefit, I suppose, from the will or a scenario like that. Again, with any document like this, it's really important that the person who's making the document is deciding who they want to appoint in these positions, and that they're people who they trust and who are appropriate. And issues like a conflict of interest would be very specific to the individual circumstances, but particularly with wills, I'd recommend, again, proper legal advice, because if there is an issue or if there is a conflict that arises, wills can be very difficult to deal with from a legal point of view. So disputes can end up in the Supreme Court, and it gets very expensive and very messy. So good to seek the advice before drafting the will and making sure the will is drafted properly.
Very sound advice, Elise. We did have another question, which was, what is the prevalence of financial abuse? And I believe Doris addressed that in her presentation. So we might move to the next question. Wanting to know some strategies for how to have a discussion about financial matters without offending the person if they're unwilling to discuss. I think this might be one for Kate and maybe APEA. You're on.
Sorry, Caroline. Yeah, so obviously if there is an advance care directive in place and there is any conflict or any questions in that space, we can absolutely assist. And in fact, or you can call our information service as well and have a conversation with our information officer about that. And we can certainly assist. I think some of the things, we work in the conflict space all the time, I think, and can assist people with conflict coaching and trying to have conversations. I think it's really difficult space to work in, but I think having clear and open communication, being clear about what your wishes are and letting your family members know that is vitally important in this space. So I'm not sure if I answered that question well, but if someone else might want to jump in as well.
Anyone else want to add to that? I think you did a good job, Kate.
Thanks, Caroline.
So I can move on to the next question, and feel free, because I'm just reading the questions that we got at the beginning, and I know there's more coming in the chat, but do send them in. We might not get through all of them, but we will come back, and you might also want further clarification too, if possible. So the next one is quite long. One elder sibling has full power of attorney, medical / financial, etc. He provides very little, if any, communication, particularly around our parent finances. Our parent has now been in a nursing home for about 5 years. How can other siblings know or have any idea about what is really happening with our parents / money? I think at least two people should be nominated as power of attorney by law. The whole thing being based on the trust of one person seems fraught with potential temptation, secrecy, and easy abuse. I'm going to throw this to Elise, but I'm also going to add Kate, because I can certainly see at least those two agencies, and then I'd welcome certainly SAPO and ARIS to add anything after We'll start with Elise.
Thanks, Caroline. Look, I think this is actually not an uncommon scenario that people find themselves in, when there might be some siblings and one is appointed under one of these documents and the other siblings don't really know a lot about what's going on. Or they might have actual concerns, some quite legitimate concerns that perhaps power is being misused. The scenario that I gave in my presentation today was when the older person or the person who'd made the document still had the ability to update it and change it. So that's always an option if the older person wants to do that and has changed their mind. It gets a bit tricky if there's concerns about these documents and that person has lost that legal ability to update their document. And that might be a situation where SACAT, our tribunal, an application might need to be made to look at whether something else needs to be put in place, some other orders. And again, legal advice in that scenario is really important. I think it's important for the family to know that they can seek that legal advice. So for example, they can call our free legal helpline and say, look, I'm not really sure what's going on here and I don't have a lot of information, but I have these concerns. And certainly concerned family members could also look at perhaps making contact with the adult safeguarding unit if they had specific concerns. As Doris noted, the safeguarding unit has the ability to investigate in certain circumstances, maybe gather some financial information. But I think in terms of obtaining that information from a person who's appointed as a power of attorney, for example, it is quite tricky if that person's not willing to do that. And it might have been something that could be incorporated into the document when it was drafted, something along those lines. And again, it comes back to that's why that initial advice is so vital and so key there. So yes, that's probably from a legal point of view what I can say, but I'm happy to hear from Kate or Doris as well.
So over to you, Kate.
Yeah, sure. So I think exactly, I agree with Elise. I think, again, and I'm plug our dispute resolution service, if there's an advanced care directive in place and a power of attorney, and there are concerns, often they go hand in hand. People appoint the same person as their attorney, as their substitute decision maker, and there's conflict or people aren't sharing information. We can help with that. You can make an application to our office and we can try and assist. I always ask people, what is the concern? So what is the concern about the decision making? So if they're making decisions and they're just not telling you, but the decisions are okay decisions and there isn't any harm to the adult in relation to their lifestyle or in relation to the finances, then it's just about communication between the parties and we can perhaps assist with that. If there are concerns actually about what decisions are being made, and then Elise is right, then potentially if we can't resolve that and get to the bottom of that, then potentially SACAT can get involved, and someone might have to be removed as a substitute decision maker and a guardian appointed. So yeah.
So any other comments from the panel? I think Doris.
Just add also, yeah, I totally agree with both Kate and Elise. As the person is in an aged care home, it's usually about siblings having conflict in regards to mum's care, especially if the person who holds that advanced care directive is not really looking after the best interests of mum, and that could be the reason why information is not being shared with the other siblings. So yeah, the first thing would be suggesting to contact APEA and have that mediation resolution service. But sometimes people don't want to attend, don't want to get involved in that sort of like mediation process. So I think in that situation, and the other siblings do have grave concerns for mum's care, then an application would certainly be made to SACAT, I would suggest. Thank you, Karen.
Excellent. So the next question, and I'm mindful of time, we've got 5 more minutes, and I'm getting more and more text things coming through to me. So where to direct carers, friends, family for resources if they have concerns or are worried about elder abuse, particularly financial abuse may become an issue. I thought if each of the panellists could just provide an overview of any resources that you might have. So we might start with, we'll start with Elise. Thanks.
Sure. So I've mentioned a number of times that anyone can contact our office for legal advice. So via our free legal helpline is the usual best starting point. On our website, so www.lsc.gov.au, we have a number of resources, including some publications that can be downloaded, publications on enduring power of attorney, on advanced care directives, on wills. We also have a free law handbook, which contains some legal information in plain English that can be accessed as well. And in relation to powers of attorney specifically, my office has a do-it-yourself kit, which has the power of attorney form itself, along with some a guide on how to complete it. And that's available to purchase from us too. Yes, so via our website is the best way to access some of those resources.
Fantastic. Deborah from SAPOL.
Yeah, thank you. We have information brochures in most police stations now, and with our victim contact officers and at community engagement sections, and it's meant to do with ARIS, as well as also referring to the adult safeguarding unit through SA Health, because quite often people feel it's quite intimidating to come and report matters firstly to police, because like we have all discussed, it can be their adult children that may be doing this to them. So they don't want the criminal justice system involved at that stage. But look, if it has gotten to the stage that they've want to come and make a report to the police, look, by all means, please do attend a police station. Or if they're in an aged care home and mobility is an issue, they can call their police attendance line on 131 444 and have initial patrols come out and speak to them at that location. So, but yeah, generally we would tend to either say speak to ARIS first or speak to the adult safeguarding unit, and we have referral pathways. So if people do happen to report through ARIS or adult safeguarding unit and they feel that they want to take that next step with police involvement and the criminal justice system, your organisations can actually refer into police without having to then take the next step of going to police stations. They can refer directly to us.
Thank you so much. And Kate.
Yeah, so everyone's covered everything. Our website has some great fact sheets as well about dispute resolution, advanced care directives, guardianship. But the one other thing, we refer to Adult Safeguarding Unit and ARIS and SAPOL and Legal Services, but also Uniting Communities Elder Abuse Unit is a fantastic resource. And I know they work really closely with the Adult Safeguarding Unit and will refer, and they have lawyers on staff there as well. So they're a really good resource.
Thank you. And Doris, would you like to?
Yes, so look, have a look on our website, the ARIS website. We certainly do have lots and lots of information there about all sorts of things, including advanced care directives, powers of attorney, going into an aged care facility, connecting to, my aged care services. So we also have the navigator who will support people to connect to my aged care. So lots of information there, but, as well as APEA's website, apea.org.au, also has lots of resources there as well. So if people want to contact us for any of the resources, we will post them out to you if you're not able to download them, because I know a lot of people do not have IT, where they can download the information. So we can certainly post them out to you free. And if anyone knows of someone who is experiencing some form of abuse, please contact ARIS. So we also do have the OPAN number, which is the Older Person Advocacy Network for after hours, and it's 1800 700 600. So people can contact us. They can contact us anonymously, and you will be responded to firstly by intake, and then with an advocate within 10 working days. Thank you.
Thank you. And time is up. I can't believe how fast the webinar has gone. It is, time flies. And I've still got more questions. So as I said, that's all the time we have today in terms of the webinar, but we will address those questions and provide that feedback to you. So before we end our webinar, can I request all of you to give us your feedback by answering this question on your screen? So you have a poll. So I'll just give everyone a few more few more seconds, I should say. So thank you again for everyone who's joined us today for the webinar. The recording of this webinar will be emailed to everyone by the end of this week. If you have any additional questions, which I certainly have, or you would like to connect with APEA members, you can do so by visiting the APEA website at www.apea.org.au. Thank you for your time and enjoy the rest of your day. Goodbye.
Thank you.